Hey out there, legal warriors. Assault charges. Man, that sounds serious. An assault charge, especially assault in the fourth degree. How is it that you can get that type of charge dismissed? You're interested in the law? You're interested in this type of thing? If so, stay tuned because this is a video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years. And I'm putting out these videos to help educate the public. So if you find it useful, please like and please subscribe. More people will get the help they need. Now let's just jump right into it. Assault. Man, that's a serious sounding charge. What is assault? And how might we get an assault charge dismissed? What do we do to defend that type of thing? Well, assault in Washington State is basically any unwanted touching. And there's different levels of assault based upon the level of injury to the victim, whether or not weapons were used in the matter, stuff, and sort of the category of the victim too, stuff like that. So the most common assault charge is some type of unwanted touching where there was no stitches and no broken bones, and they weren't like a medical professional providing services or a cop, okay, police officer. So in that type of case, a standard variety, push, shove, punch, kick, spit, throw water in someone's face or beer or whatnot, that's called assault in the fourth degree. And if that person is not a family or household member, if they're not someone you've dated or lived with and not a relative, that's probably not a domestic violence charge. So this video is about assault in the fourth degree, not domestic violence. We've got a lot of videos on assault in the fourth degree domestic violence, but this type of charge is different. There's different things to consider, there's different ways out, and there's different priorities for a prosecutor in this type of case. And it gets complicated, but I'll try to explain. So if you're charged with assault in the fourth degree, your first court date is going to be called an arraignment. Okay, in an arraignment, if you get a private attorney in an assault 4 charge, we're often able to waive the first court date if you have an attorney and enter a not guilty plea for you. If you don't have an attorney, you need to go to court. If you do have an attorney, then see if that attorney could waive your first court date, because there's special rules for non-domestic violence cases where we may be able to waive that first court date. So after the first court date, there's a pre-trial hearing, and then we start doing our defense stuff. So how might we get an assault in the fourth case dismissed? Well, I've done some videos on it recently. There is something called compromise of a misdemeanor. It's a little bit harder to do in an assault case, but it's not impossible. If there's a law in this state, RCW 10.22.010, that says if a victim of a crime has a civil cause of action where they could sue you for money separate from the criminal case, and they appear and say they've been satisfied for their civil cause of action, they've been paid some money to satisfy what they could sue you for, then the court in its discretion can dismiss the case against you. Okay, this does not apply to domestic violence cases. This does not apply to felony cases. Does not apply to anything done riotlessly or in a riot. You know, more than 3 people is what that means. But for most assault 4 cases, the victim does have a civil cause of action. They have some damages. They got a bruise. They got pain. They got a cut. They got torn clothing. Who knows, right? Maybe medical bills. And so, in that case, your attorney may be able to reach out to the victim and say, hey, could we compensate you for your damages? And could you sign a release releasing my client from civil liability? They do not have to agree to release you from criminal liability. That's not in the statute, though a prosecutor may think that. And if we get that release, then we can file a motion with the court asking them to dismiss the case. Now, why is this hard in an assault case? Well, oftentimes the alleged victim's pretty mad, okay, about the assault. The exceptions may be bouncers. We've in bar cases, we've had plenty of cases dismissed on the compromise of misdemeanor when a bouncer, you know, got into it and someone got charged with assault at the bar. You know, that's not so personal to them maybe, but in the most cases that, you know, it might be a whole new situation. The alleged victim has not been in this situation before and they're really mad about it. So it can be hard that way sometimes. It can also be hard because some prosecutors and even courts don't like the idea of dismissing cases in an assault by compromise of misdemeanor, even though it's allowed, but it's discretionary with the court because it just seems wrong to them. Okay, so it depends. Your mileage may vary based upon your victim's attitude and the court and the prosecutor's attitude, whether that's possible. So that's one way to get an assault in the fourth case charge dismissed. The second way is self-defense, right? Just because there's unwanted touching on someone doesn't mean that it wasn't justified by self-defense. So in Washington State, the prosecutor has to prove a lack of self-defense beyond a reasonable doubt, right? So, which means that self-defense can be a pretty good way to defend an assault charge, because most assault charges that are between strangers sort of happen in a dynamic environment where each person has a totally different version, right? And the police officer just usually happens to charge the person who won the fight, right? The person who won the fight doesn't have the bloody nose. The person who has the bloody nose looks like they lost the fight, so usually the defendant is the person who won the fight, okay? So, but maybe you got attacked first and you used a reasonable amount of force to defend yourself. And you can't just use a disproportionate amount of force, right? If someone is coming at you with, a feather, you can't come at them with a hammer. If someone's coming at you with their fist, you probably can't shoot them, okay? At least not in this state. So for self-defense, we have to consider whether or not we were under imminent threat, being attacked right now, versus just being, I'm scared I might get attacked, right? And whether or not the amount of force we used was reasonable and proportionate to the threat we faced, right? If we have to defend ourselves and they end up in the ground and we get on top of them and still keep pounding them, right? Well, it might have been self-defense to get them on the ground, but it was probably assault when we kept assaulting them when it was no longer necessary, at least in the eyes of the officers, right? We might say, well, it was necessary because this person could have got up and kept doing stuff to us. But self-defense is a really good defense in certain fact patterns, but it's not as many as you would think. And one of the unusual parts of Washington law is, at least if you have a state case and you are found not guilty and you prove that you use self-defense by a preponderance on a jury instruction form, the state can be ordered to pay your defense attorney fees. Okay, and so it's very rare that it happens, but it's in the law, and it has happened before. So self-defense is another way in certain fact patterns to get an assault fourth degree charge dismissed. What's another way? Well, negotiation. Okay, and you've probably heard me talk about this before. There's lots of reasons why a prosecutor may not be that interested in taking your case to trial, right? Everybody in the system is self-interested. The prosecutor has a job to respond to your case, but they don't have a job to let you go. Okay, so they don't have to let you go, but they do have to respond in their mind in some way. So if you do some things in your case, maybe we do an anger management class to show that we've learned from the situation. Maybe we have a really good record, right? Maybe we do some counseling. Maybe we pay for the damages on top of all of it. And, that gives the prosecutor a way to consider giving you some way out of the case without taking you all the way to a trial. So prosecutor might dismiss the case if you do enough stuff because we can't tell what happened. The prosecutor might give you a stipulated order of continuance, which is an agreement to continue the case without a finding, to eventually hopefully have your case dismissed with lawful behavior, right? So that's another way to get your assault charge dismissed. And what's probably the final and the hardest way to get it dismissed? Well, is to go to trial and win either on what I just talked about, self-defense, or just the fact that there wasn't an assault. Hey, this person says I pushed them, I didn't. They haven't proved that I pushed them. And why isn't trial the first choice? Well, it's really tough to go through a trial, right? You're already stressed. Imagine what it's going to be like, everyone saying you did something wrong and spending all this time and money, in a trial like you see on TV. Also, while trial's not a great first choice, is you lose control of the outcome, right? Do we want 6 people who, what I say is, maybe weren't smart enough to find their way out of jury duty or just interested too much in the criminal side of things? Do we want them deciding your fate? Or do we want you and your attorney getting an offer out of the prosecutor or getting a result from the judge that decides your fate? Because nowadays people are mad, okay? People are mad about everything going on in the country, the political divide, the financial issues, the healthcare crisis with COVID, and I think that people are more likely on a jury, at least, to convict people right now because they're mad. And so, and there's all these witnesses typically that are going to be against the defendant and not so many for the defendant, right? Every case is different, so that's why going to trial is sometimes necessary and sometimes the right decision. But a really good case typically doesn't get to trial. The prosecutor will see that, and if you've done the right things, oftentimes it'll go away prior to that. So those are some ways to get your assault charge dismissed. You may have questions about that. You can put them in the comments. I'm happy to look at those. And if you have a legal problem like this or any other criminal problem, feel free to give my office a call, right? We can listen to what happened, we can identify a way forward, and we will be there for you. Thank you.